Good afternoon, everyone. I hope all of you are doing great. Please confirm me that my voice is fine and you are all set to start. Then we are going to start. So comment section is open for you. So today we are going to discuss Article 19 to Article 22, Right to Freedom. Along with this, we are going to discuss all important cases pertaining to these provisions, and we are also going to attempt some important MCQs. All of you are welcome to ask your doubts regarding these articles. Please confirm your presence in comment section that everything is fine. So today we need to talk about Article 19 to Article 22. Have you ever wondered why right to freedom was so much important that these rights were added as fundamental right? Some of you might think, yeah, we got our independence. There was a struggle for freedom which was going on. And how can constitutional framers miss on this particular provision or these range of rights, right? Please confirm in comments that my voice is fine. Welcome, Uday. Great. So let's start with Article 19. We are going to discuss article by article. First, let's talk about Article 19. Article 19 consists of 6 types of rights associated with your freedom. It's starting from right regarding your speech and expression. Now, why this particular right was added and what kind of rights associated with this particular phrase speech and expression. So when I say speech and expression, it was very important to give you this as a fundamental right because this is important for you to realize your potential. And it is said that no government, no nation can become great without dwarfing their own individual. So it means you cannot put limitation on this aspect of our personality, right? Now, apart from this speech and expression, we have right to assemble peacefully, we have right to form association, we have right to move, we have right to reside, and we have right to choose occupation of our choice. You can remember all of these rights by a simple story. Let's start. Consider you are present in my class and one student, Uday, rose up to the platform as I was sitting in staff room. So he took this opportunity and he started speaking that there was a time when UPSC used to have more than 1,300 vacancies per year. But now vacancies are considerably low, and this is wrong because more than 4,000 seats related to IAS officers are needed. They are vacant. So what he's doing, he's exercising his fundamental right as mentioned in Article 19, subclause 1, subclause A. Please remember, all these 6 rights are mentioned in Article 19, subclause 1 because subclause 2 pertains to reasonable restrictions related to Article 19. Okay? So all 6 rights in subclause 1. Now, so just remember from Uday's story. First he started speaking. Now, you got this opportunity that now let's start discussing this among other students who are in this area where coachings are. Say you are in Karol Bagh. And all of you actually came down from the class and you assembled in front of coaching, right? And there Uday started speaking saying that in 2015, our senior aspirants, they fought a battle and thereby finally government increased the number of attempts. Earlier number of attempts for general category were 4, then they were increased to 6. So we can have same kind of battle and thereby we can budge government, we can pressurize government to increase the number of seats. Now the point is, first he was speaking, now he make all of you assemble. So all of you assembled. Now, all of you are assembled and many people were passing by. And you know what happens in India? If some 6-7 people or say 50 people are assembling, then other people who have nothing to do with you, they will also come and stand there. What is happening, right? So people were coming. But now many people were again and again asking, what is happening? Why you people are standing here? So at this point, Uday suggested, let's form an association. So he called up another student, Rohan. Rohan, bring a banner that All India UPSC Aspirant Association. So Rohan printed the banner and came with the banner, and now you have an association. So first step was speak, second was assemble, and third was banner of this association. So 3 rights are intact. Now, so all of you are assembled with your banner in Karol Bagh. But this country is run not from Karol Bagh, although people selected from Karol Bagh are running the country, but key decision makers are sitting where? Near Parliament Street. So at this point, all of you made a decision, let's move towards Parliament. So what you are doing? You are exercising your fundamental right as mentioned in Article 19 subclause 1 that you can move freely within Indian territory. So now you moved towards Parliament Street. So this was your 4th step. Now all of you were on this Parliament Street and many cars were passing by of these politicians and no one was actually stopping and asking you. So you were thinking कि इन्होंने तो हल्के में ले लिया हमको. No one is giving importance. So now you thought they are thinking that we are the students and we will go back in the evening to our PGs or rooms. Now to make your stand strong, you said all of us, let's reside there. Let's install temporary tents here. Because farmers also got something by installing tents. Let's install tents here. So now you started installing tents. Okay, I'm not talking about legal aspect. I'm just talking about what is going on there. Okay, and why you are doing. You are doing this that because in fundamental right, Article 19 subclause 1, you have next right to reside in any part of Indian territory. So you exercise this right. This was your interpretation, right? And you started, just sitting there and you installed some tents. Now, then only no action was taken by government. So now one student suggested, it may be possible that we are lacking in something. What is that thing? So others suggested, we are not having media coverage. Farmers got success because they were hugely, they were covered internationally too. We are not having coverage even in local newspaper or local channels. So someone suggested, we have to do something for TRP. Then you exercise your next fundamental right mentioned in Article 19 subclause 1, right to adopt occupation or profession of your choice. So now you gave this idea. So let's install some pakora shops there. So now media will cover the cream of India, the people who are preparing for civil service exam, intellectual students. Now they are bound to actually prepare pakoras sitting on this road. So now what you use this 6th right, right? So in this story, now just go back to the story from where you started. Right to freedom of speech and expression, Uday started. Aag to Uday ne lagai thi. Now, right to assemble anywhere without arms, peacefully, right? Second step was this. Right to form association, Rohan brought this banner. Right to move anywhere, you move towards Parliament Street. Right to reside anywhere and settle. 5th right, that is why you installed tamboos there. Right to adopt occupation, profession. This is your 6th right, right? I hope now you will remember all these 6 rights mentioned in Article 19 subclause 1. Yes or no, yes or no? Now, you should remember some other details too. For example, Article 19 is applicable only for Indian citizens. Okay, these rights cannot be exercised. Means, although foreigners can come and they can actually speak, okay, they have this freedom, but they cannot say that if this freedom is abridged, I will go to Supreme Court. Okay, many students misconstrued that if it is written that Article 19 subclause 1 is applicable only to citizen, then they think, oh, if foreigners, aliens, enemy aliens, they don't have any right respect to freedom of speech and expression. No, that is your misunderstanding. They have the right, but they don't have the fundamental right. They cannot knock the doors of Supreme Court using Article 32. They cannot knock the doors of High Court using Article 226. I hope you got the difference, right? Also, please remember, no fundamental right in our Constitution is absolute in nature. Okay? They all are qualified in nature. Qualified. So what is the meaning of this word qualified if this is used in statement? Qualified means reasonable restrictions are also mentioned. And why our constitutional framers also added reasonable restrictions within Part 3 of Indian Constitution? Because they were aware of this fact that no one's fundamental right should not abridge the fundamental right of other. Otherwise, it will become a legal issue, right? That is why a balance is needed. To bring this balance, our fundamental rights were given the status of qualified fundamental rights, not absolute fundamental rights. Not absolute. Okay? Now we are going to discuss each right, right? Freedom of speech and expression. So, what constitutes freedom of speech and expression? You have freedom to express your views, expression, belief, conviction freely. It means when I'm saying speech and expression, you should not take this just in literal sense. Oh, it is just about speaking. No, no, no. Your belief also comes into this. Please remember these kind of details, because a beautiful trap question, trap statements can be made on this and student will get confused. Okay, so belief is also part of this, because when you have belief, your belief is connected to your expression, right? Now, it also includes what you say from your mouth, writing, picturing, etc. Okay, for example, few years back, one cartoonist, Mr. Asim Trivedi, so a case was lodged against him using Information Technology Act, Section 66A. We are going to talk about this section in upcoming slides. But at that point of time, Asim Trivedi's advocate said, this is against Article 19, Subclause 1, freedom of speech and expression as fundamental right of my client. At that point of time, court said, your expression also includes picturing. And this Asim Trivedi made a cartoon of our national emblem, which was derogatory in nature, right? And that is why it comes under reasonable restriction. Okay, so he exercises saying picturing is also speech and expression, but reasonable restriction does play on that. So when I'm saying reasonable restrictions again and again, so what constitutes reasonable restrictions? It includes if your expression is threat to sovereignty of India, integrity of India, security of India, public order. It means you are making a speech and due to this, there is a law and order issue. Okay, so at that point of time, you will see a knock on your door and police will say, be our guest for some time and have food in jail. Okay, this can happen. Jail is at later stage. First you will go to Havalat. Now, contempt of court and defamation. Please remember these two also, because most of the students remember sovereignty, integrity, security, public order, right? But these two are also reasonable restriction, contempt of court and defamation. Okay. Now, in Article 19, some rights are explicitly mentioned, but some rights, some fundamental rights are implicit, as they are declared by honorable court time to time. When I'm saying honorable court, I'm talking about Supreme Court here, although interpretation power is with High Court as well. So these rights are coming under right to speech and expression. Okay, among these, some will seem obvious to you, and in some others, some students may have some dicey opinion. You should not have dicey opinion. Look, take a look. Right to propagate one's views as well as views of others. So this is your freedom of speech and expression. Okay. Freedom of press, please remember, freedom of press is not mentioned in our constitution, but it is derived from Article 19, Subclause 1. UPSC play game on these words: mentioned, derived, inspired, interpreted. So have some focus here. Okay, these are derived provisions. Okay, right to telecast. Right to telecast means government cannot stop telecasting service arbitrarily. Now take into consideration case of NDTV. All of you are aware about Mr. Ravish Kumar, and you also know that he is quite favorite of present government, right, as he is quite appreciative of ruling government at center, right, and that is why a few years back NDTV was banned, telecast was banned for one day. So advocate of NDTV said it is against Article 19 subclause 1, freedom of speech and expression, because right to telecast is also derived from here. So at this point of time, court said accepted, right to telecast is there, but government has a ground there. Why they are stopping telecasting? Because it is creating a public order issue. Government think it is creating a public order issue. On this point, government stopped the telecast for one day. Okay, so no government has monopoly here, obviously, right? Government cannot say now there will be no channel, no private channel, only government channel will be there, and whole day you will have bhajan kirtan of the achievements of government on these channel, because that should not happen. This will be against freedom of speech and expression. Okay, now freedom of silence. Okay, but you should not exercise this right in this class. If I ask you some question, which I am going to ask when I am going to talk about some MCQs, so you should not exercise your right to silence. Okay, but you should know that right to silence is part of speech and expression, and it is a fundamental right. Okay, now right against bandh. Now bandh, what is bandh? For example, a political party or any organization, they say we are starting Bharat Bandh on 11th say March, there will be Bharat Bandh. So against that Bandh you have right. Okay, you can actually go to your office, you can go to your classroom. That Bandh is cannot stop your, you can say, movement, right, because this is from a political organization, right. Right to demonstrate, picketing, but not right to strike. Now please remember, I'm making a statement, okay, to make you understand it more clearly, and I would appreciate if you respond. Which of the following statement is correct? चलिए एक ही statement बना रहे हैं. There's one statement. There is no right to strike. There is no right to strike in India, comma, although there is right to put forth your apprehensions before the establishment in a peaceful manner. Now tell me, my friends, this statement is true or false? Dharmen, this PDF will be available in the group, Telegram group, Shashank Tyagi for you. I'll show the link in the last, don't worry. So I'm repeating the statement and all of you have to respond, okay? So we are in Indian polity, and I'm going to continue only when I get simple majority responses here. Means more than 50% of present and watching should give answer, then only we are going to continue, okay? Now, I'm repeating. There is no concept of right to strike applicable in India, comma, although people have right to present their apprehensions before establishment in peaceful manner. This statement is true or false? Come on. All of you should respond. This statement is true or false? Uday, Dheeraj, Piyush, Dharmendra. I hope voice is fine, streaming is fine. Because Guys, everything is working top notch at my end. Yeah. So Ramay is saying true. Okay. What about others? Piyush is saying true, right? Dharmendra is saying true, right? So all of you are smart students. You have Shashi Yadav is asking the question. Piyush is saying, sir, voice is fine. Okay. I am repeating the question one last time again. Okay. Pankaj is saying true. All of you are united on true. Shashi, the question was right to strike. You can say go back into the streaming and you can actually listen to the question. Otherwise, it would be injustice for the students who are continuously listening to me clearly. I hope you will understand. Now, my friends, to your surprise, answer to this statement is false. It is false. Surprise? It is not a surprise. Now understand how it is false. Here I have mentioned right to demonstrate or picketing, but not right to strike, right? And from this you deduce this, and this is exactly what students do after reading Lakshmikant, right? And now understand why it is false. Because right to strike is not a fundamental right. Means right to strike is not a fundamental right, but it is a legal right. And now go back to my statement. I said right to strike is not applicable in India. Have I said right to strike is not fundamental right? No. I have just said right to strike is not applicable. So why all of you said true? Because there's a psychology working here and UPSC play on this. I call this personally blending technique. Blending technique is make half statement a vague one where students do not have clarity, and make other half of the statement as the genuinely true statement, so that by the end, when student reaches the end of the statement, a student will make up his mind, oh, this statement is quite obviously true. But my friends, this is a trap in which many aspirants actually get entangled every year. But I don't want any one of you to get into this trap. It is a legal right. Now, explanation why it is a legal right? Because we have a law, Industrial Disputes Act. And within Industrial Disputes Act, there is a section 22. And this section 22 gives you right to strike in case the contract on which your employment was ensured, this contract is not actually being followed by your employer. In that case also, you have this right to strike only when you present notice to your employer. So it means by this particular law, right to strike is a legal right. Okay. So if it is clear to you now, mention HOLA, H-O-L-A, because yes is too obvious, boring. So if it is clear to you now, mention HOLA, HOLA in comments. And I hope now you are not going to make this mistake in exam. Saved you from one accident. Let's continue. In comments, everyone. And I would highly appreciate if you want your friends to join in this live session. You can share this link in your groups or with your friends. They can also participate in this question exercises, which are important for upcoming prelims. Let's see where students are moving. Chaliye. Now, take a look over this headline. Supreme Court upholds freedom of speech on internet. It means now your freedom of speech is also applicable with respect to internet, okay? And strikes down draconian law. So what draconian law Supreme Court was talking about? Supreme Court was talking about section 66A of Information Technology Act. And some of you might think, sir, it was a good act. It was a good provision, because just I shared this case of Asim Trivedi, right? So then why Supreme Court struck down? The word draconian is used because in so many cases our government, our police, they actually misused this particular section. For example, if Uday has put a post on against some action made by present government, so it may be possible that next morning a knock on Uday's door and police has come and police said, sir, aapko chalna hoga, you have to go, because under section 66A we are arresting you. Then Uday's parents are asking, why? Our child is studying throughout day and night, why are you arresting him? He is the future of India. Now police is saying, sir, we are going to make his future in police station, because last night he has posted a status on his Facebook and Twitter, and this has been retweeted and shared many times, and now many people are raising voice against the government, and that is why it can create a public order issue. Okay, so our best wishes with Uday. But Uday, you should remember, Supreme Court is in your favor. Supreme Court is saying section 66A should not be applicable because it was misused, right? But the reality is, to your surprise, that still in many cases it was found that local establishment, the police at the local level, was unaware of this Supreme Court judgment, and in their charge sheet they were actually adding this section 66A. Okay, apart from section 66A, also remember two sections of IPC, section 153 and section 505. Please remember, these two sections of IPC are also used in case of hate speech, which was also in news. Hate speech. It means if your speech is inciting mob to act in anger and there's a probability of violence or animosity among public, then again a knock can be on your door, and the basis would be section 153 and section 505. If everything is clear until now, mention yes in comments. Now, apart from this, within your speech and expression, this homosexuality case can also be read. So India's Supreme Court decriminalizes homosexuality, historic LGBT community. You all know about Navtej Singh Johar versus Union of India, right? At this particular judgment, Supreme Court said, your sexuality is also a part of your expression, and your expression is your fundamental right under Article 19, subclause 1. Okay? Now, Article 19, subclause 2, freedom to assemble. Now, this freedom to assemble is assemble peacefully. When I say peacefully, it means without arms. Okay? Without arms. And when I say assemble, it includes, public meetings, demonstration, take out processions on public land only. You cannot do this, you cannot exercise this fundamental right on a private property. Okay? No violent protest, riots, assemblies involves arms, could breach public peace. Okay? Now, I'm making a statement and you have to tell me the statement is true or false. Okay? Tireless study zone, answer to your question is yes. Now, no group or community is allowed to assemble with arms as an exercise of their right to assemble. I am repeating, no community or group in India is allowed to assemble with an arm, okay, as a matter of their right to assemble under Article 19, subclause 2. So what would be your response? The statement is true or false? Come on, fast. We have to make it like a rapid fire round. Then only I can add more value into your preparation in limited time which we have right now. Come on, fast, fast, fast. Good response, Sajal, as was expected from you. Answer is false. Answer is false. The reason is because Sikh community is given exception. The Kripan was declared that this is essential part of their religion, and that is why they can assemble with Kripan. But obviously, this Kripan cannot be used for violence. Okay, I hope it is clear now. Reasonable restrictions are also there. Now you have two sections which are related to this restriction with respect to assembly. Please remember section 144 CPC and section 141 IPC. Magistrate can restrain assembly if meeting or possession cause obstruction, danger, damage, health or safety disturbance rights. In this case, assembly can be restricted. Now you cannot knock on the door of Supreme Court using Article 32 that my Article 19 subclause 2 is abridged. 5 or more persons, if they are assembling and section 141 of IPC is in place, then that particular act can be considered as a crime. Please remember, it was in place, right, many times during the farmers' protest as well. Also was applicable in many areas during this COVID first wave, second wave, right? Now, right to strike. I hope now it is clear to you. I have just shared this question. Answer is legal right. And this is legal right. I have already explained to you using section 22 of Industrial Disputes Act 1947. Or I have already explained this to you. Now, Article 19 subclause 3, freedom of association. Now, this is also your fundamental right. It means you can form association, union, cooperative society. Cooperative society word was later added. Okay. Now, I am making a statement and you have to tell me statement is true or false. Under Article 19 subclause 3, Indian citizens are given fundamental right to get their society, association registered with government. This statement is true or false? Come on fast, everyone. I am repeating again. Under Article 19 subclause 3, Indian citizens are given right to form and register their association with Indian establishment or Indian government. A statement is true or false? Form and register, two words are used here. Come on. Everyone, Sudarshan, Uday, Piyush, Dharmendra, Sajal. It should be quick. Because in prelims, your responses are quick. Answer is false. एक तो होता है गलत, एक होता है सरासर कैटेगरी का गलत. सरासर wrong. Okay, this was sarasar. The reason is registered word is not mentioned here. Registered is not fundamental right. You can form your association, but it is not like, sir, that SDM is not registering our association. That SDM might be having some objections in mind related to the work you are going to pursue in that area, right? That is why the answer to the statement is false. Okay, you have right to form association, but right to get registered is not fundamental right. I hope you got it. If you got it, mention in comments. Right to form company, society, trade union, partnership, firm, club, etc. But the word is form. I hope it is clear. Mention got it in comments. ऐसे नहीं चलेगा. I should be aware that you are getting value from this discussion. Establishment, administration and functioning are part of this particular fundamental right, but registering word is not there. Now, Article 19 subclause 4 talks about freedom of movement. Now, I am making another statement, okay? Because in the story I have already explained to you that right to movement, and I have also mentioned that this fundamental right gives you this right to move freely within the Indian territory. Then can you say that this Article 19 subclause 4 also gives you fundamental right to travel abroad, means to move out of country, is also your fundamental right under Article 19 subclause 4? Come on, fast. Yes, no, yes, no. Now I am giving you another trap which UPSC may lay in the upcoming prelims. One statement is, right to move abroad is fundamental right under Article 19. Tell me, answer to this is true or false? Fast in comments. Another statement is, right to move abroad is fundamental right. Tell me, this is true or false? So this is statement 1, this is statement 2. So your answer should be 1, true, false, true, true or false. Okay, so in comments your answer should be 1T अगर आपको लगता है ये true है, 2F if you think this is false. Okay, this is how you need to put your comment. Come on, fast. I hope my handwriting is legible. Basically, it's a piece of art. Only genius people actually are able to, read it. Now in comments, fast, fast, fast. This is a rapid fire round. Piyush, Shuday, Sudarshan, everyone. What do you think? 1F, okay, 1F. One response is 1F. What about other warriors? 2T, okay, 2T, okay. Answer is 1F and 2T. Reason is because right to move abroad is not part of fundamental right under Article 19, because Article 19 talks about freedom of movement, but freedom of movement only applicable inside Indian territory, only inside. Article 19 talks about inside, okay? But second statement says right to move abroad is fundamental right. Now some of you might think, which other article has mentioned this right to move abroad as fundamental right? My friends, this is not explicitly mentioned in Indian Constitution, but it is derived from Article 21. So answer is true. Okay? In Sardar Satwant Singh Sahane case, Supreme Court declared that right to move abroad is your fundamental right. Sardar Satwant Sahane case. Okay? If it is clear to you now, mention clear. And those who are ultra clear, mention ultra clear. Now, Article 19, subclause 5, freedom of residence. So there are two categories here. Right to reside. When I am using reside, it means temporary in nature. Means stay is temporary. For example, you belong to Bangalore. Okay, your permanent residence is in Bangalore, but for some time you were in Pune. So you have this right under Article 19 subclause 5 that for your job purpose you can reside in Pune. Along with this, you also have right to settle in Pune, because domicile and permanent residence is also a right given to you by our constitution under Article 19 subclause 5. Now, is it absolute? No. There are some reasonable restrictions. For example, restriction in tribal areas. For protection of tribal rights, government may issue guideline that in this particular area, no other person except the tribals can purchase land, can settle here, so that their culture, their rights can be protected. Public interest, for public interest this can be done, right? And this word public interest is considered vague. In this particular case, government has more power to actually issue the guideline which government is considering as public interest. If any one of you is not happy with the definition of public interest which government release at that point of time, then you have this facility of using Article 32 and knock on the door of Supreme Court that I'm not happy with this definition of public interest. Now that would be the, you can say, now the ball will be in the court of Supreme Court, what Supreme Court says. Okay. Now, freedom of profession, occupation, trader, business. But it should be clear to you, it is not like now you are preparing for UPSC and you are from engineering background and now you call up your mother back in Bareilly that mummy just order a board and on that board just mention Dr. Sajal Tiwari, and tomorrow I am reaching home and from tomorrow I am going to practice as a doctor because I have read this Article 19 subclause C, subclause 6 which says freedom of profession. Since I have freedom of profession, from tomorrow I am going to practice as a doctor. Now you should also know this particular section in detail, okay, because this freedom of profession, occupation, trade is applicable, is allowed to you, but you should adhere to the qualifications which are needed and issued as a guideline by the government. Otherwise, you will be considered as a jhola chhap doctor and you will be put under arrest, okay, because life of people will be under threat because you misunderstood this particular article. Now, restrictions, technical qualification for trade business, right? For example, if you have to open even a medical store, do you need certain qualification for that? Yes or no? Do we have some guideline in place? So those who are not aware, they should know that yes, you need a degree of pharma, for example, B Pharma, to open even a medical store. And those people who don't have this degree, what jugaad they do, they actually contact a B Pharma student and tell them that just give us your degree and we are going to send you 8,000 rupees per month, right? So this is how things work. No objection, state whether monopoly or not. Means it may be possible, although you have this freedom of trade, but it may be possible in certain cases there is monopoly. For example, Uday is a bright student, right? All of you know that in the last question he answered correctly. And now he got so inspired from Article 19 subclause 6 that now he called up his friend that now I have chosen my profession. Now I have got sense of purpose in my life. Now this will be my profession for life. Now these friends were asking what you read in Article 19 subclause 6 and why you are so excited, what profession you are choosing. He said, now I am starting a missile factory in my home. I am going to build missile. I am going to build bombs in my home. And now I am going to actually spur the growth of indigenous defense manufacturing in India, which India is lacking, and I am going to make India next Israel in defense sector. So it may be possible that NIA may knock the door of Uday and take him, with them, because in certain sectors there may be monopoly. Although now, since I am giving example of defense manufacturing indigenously, government has liberalized this field too, right? But it is not like you can actually start on your own. In certain section, government can reserve, if this missile category is there, only government DRDO may engage. And if government is engaging some private sector, then government guideline will be in place, okay? No immortal occupation allowed, child trafficking, explosive, etc. Obviously, this is immoral actually. Sorry for this. This is immoral. Means it should not be like Sajal next day decide that I am going to be a drug trafficker. I am going to be, the head of drug syndicate. Okay, I'm going to be next Pablo Escobar. ऐसा नहीं हो सकता, legally at least. You cannot take this inspiration from Article 19 subclause 6. Okay, I hope all of you are clear till this point, right? Now, Article 20, another important provision, an interesting one. Look what it says. Protection against conviction of offences. Now some of you might be wondering, conviction of offences. If conviction is happening, it means now it is being proved, it is in process and it is being proved. It may be any case that this person has committed some crime. Then what kind of protection we are giving to that person? Look at the humbleness of our constitutional framers. They are thinking of them also. Now, there are 3 clauses within Article 20 and quite easy one. First is no ex post facto law. It's a Latin term. What does it mean? It means if you have committed some action, I'm using the word action, I'm not using the word crime, point to be noted. If you have committed some action, say Sudarshan has committed some action 2 days back, and that action led to some harm to Piyush. Piyush's interests have been harmed due to some action done by Uday. Now Piyush raised this point that I am going to actually file a complaint against Uday. When he went for filing complaint, police said, sir, in our code, in our criminal code, such action is not declared as a crime. Thus, we cannot say that Uday is a criminal. So Piyush was quite fed up. And Piyush Chacha is Vidhayak. So Piyush was like, Chacha Vidhayak and wo bhi BJP, and we are going to actually, we have power, and we need to be neutral politically here. No offense to anyone's political interest. But the point here is, Piyush is a person with clout, so many connections. So he called up his Chacha saying, I want a law to be made declaring this particular act as crime. Chacha said, हो जाएगा, चुनाव में बस ड्यूटी देते रहना, चुनाव में हेल्प करना. Piyush said, वो तो हैं ही आपके साथ, we are there for you. So now, even if law is made from, say, next week, emergency law is made from the next week, such is the importance of Piyush. Do you think now Uday will be arrested for an action which he committed previous week? And now that action is being declared as criminal offense? Do you think he will be arrested? Yes or no? Legally I am saying. Yes or no, yes or no, yes or no. Come on, fast, fast, fast. Answer is no. You know why? Because when Uday committed that action, when Uday did that action, at that point of time, that act was not crime. Okay? And on this interpretation, he cannot be arrested. Now, Piyush got this information. Piyush against called his Chacha. We need to actually enact this law from back date. So Chacha said, हो जाएगा. Now legal advisor of Chacha said, sir, ऐसा नहीं हो पाएगा. This cannot be done. Because in Article 20, ex post facto law is used. It means you cannot actually amend a criminal law from back date. Otherwise, it would be injustice with Uday. Uday would say, agar हमें पता होता, if we would have been aware of this fact that it can be considered as a crime, I would have not done it. This is wrong with me. This is wrong for me. That is why this no ex post facto word is used. It means criminal law cannot be amended or added from back date. Criminal. I am using the word criminal again and again. Okay? Criminal. So what does it mean? It means a law can be amended from the back date if that law is civil law. Can you actually give me some example where a civil law was amended from back date? Come on in comments, fast. Such kind of statement can be made by UPSC. Give me example. Criminal law can be amended, cannot be amended from back date, but civil law can be. Okay, so I am giving you a star point. Those who are my students from past, they know, and those who are new, remember whenever in my class I say star point, it means this is important, but this is not part of discussion which we are having in class. That is why I expect my students to search these star points, give at least 10-15 minutes, search these star points and note down some important details. Okay, because questions can be made around it. So star point from this class, from this part, is search GAAR. GAR means General Anti-Avoidance Rule. Also search about Partha Sarthi Shom Committee. Partha Sarthi Shom Committee. 1 and 2. I've given you 2 star points to search. Okay, general anti-avoidance rule and Partha Sarthi Shom committee. Okay, now coming to our second point, no double jeopardy. What does it mean? It means a person will not be punished twice for the same offense. For the same offense. If you have committed an offense, you cannot be actually punished twice. Okay. Now, third is no self-incrimination. It means that you will not be bound to be witness in your own case. Because if you are bound to be witness in your own case, then it would be against Article 20, because it may compromise the true process by which investigation and prosecution should be done. So these are 3 provisions. And why these 3 provisions were added in our constitution as fundamental right? Against arbitrary action and excessive punishment. Okay. So this is quite clear to you now from our discussion. Ex post facto law, a law which imposes penalties or convictions on the already done act, increases the penalty of such acts, and that is why it is not allowed. Only in criminal matters not allowed. Already told to you, informed you. In civil matters it is allowed. A tax can be imposed retrospectively. Okay. Income Tax Act was amended retrospectively, and there was a lot of hue and cry. Double jeopardy, no punishment for the same crime more than once. Self-incrimination, self-witness not allowed. Now, UPSC is not going to play on these basics. Let me tell you, gone are those days. Now, UPSC is going to play along these lines. Now, attempt the question. And I want answers in comment. It doesn't matter whether you answer right or wrong. Okay. Your response are respected. Okay. What matters is that you are responding or attempting. Because there is a rule in psychology. If you attempt wrong and you immediately get the right answer, then you're not going to forget it easily. And this is our purpose, to contest. Polity should be contest to you. Sudarshan, retrospective taxation means if you amend tax law from the back date. For example, consider right now you are in 20% tax slab category. Okay, 20% tax slab category. Now government changed the tax law from previous year. So if government change this particular tax law from previous year, now don't you think now your tax liability will increase? Change the means government changes, and this change increased the tax slab. Now you are in 30% tax slab category. So it means for previous year you paid 20% tax, right? And now government from previous year changed it to 30%. It means you have to pay 30% for this year as well as pay the balance amount from previous year. So Sudarshan, if you are clear now, mention clear. Come on. I would rest. If it is clear, mention clear. Now, response to this question. Self-incrimination as mentioned in Article 20 of Indian Constitution extends to. Some are saying A, some saying B. Is it? Extends to A. Actually, I was saying that UPSC is going to ask questions like this. This is quite direct question. Okay, this is quite direct question. I have another question in my package. I thought that question has showed up. This is direct question. This is lollipop. Okay, this is not what I meant. Yeah, attempt this question. Double jeopardy is not available in proceedings before. This is good. It will show some understanding, not just about the word, but about the application also. And UPSC want exactly that. Proceedings before court, proceedings before judicial tribunal, proceedings before court and departmental authority, proceedings before department and administrative authority. Answer is D. Answer is D. Double jeopardy is available only in proceedings before a court of law or judicial tribunal. Okay. Now remember, what was the double jeopardy? It means you will not be punished twice for the same offense by any court or judicial tribunal. Okay. But you can be punished twice in case proceedings before department or administrative authority. For example, you are an IS officer, a bright one, but highly corrupt. So a corruption case was lodged against you, and it was proven that you have just 300 crore worth property in 6 years of service. So don't you think it is an extraordinary achievement? So considering this extraordinary achievement in mind, a case will be lodged, case will proceed in court also, right? And your file will be transferred to UPSC as well as Department of Personnel and Training of Union Government. That this is a bright start, take a look over his or her file. So in that case, a departmental, you can say, action can be taken against you. You cannot say that, oh, I am already punished by the court, why department action is being taken against me? And department can also take multiple action against you. Okay, may impose fine, may take your job, a lot of things can be done, right? Fun things. So please remember, double jeopardy will not come there to protect you. Okay, I hope it is clear. Now, Article 21, protection of life and personal liberty, most popular fundamental right, right? Now, no person, this is the language, okay, and by interpretation, the meaning of this language has also been expanded, okay? And there's a popular phrase that Indian Constitution is a growing tree. And why growing tree? Because a lot of interpretations have emerged, right? And specifically Article 21, from Article 21, we have list of fundamental rights which have emerged. No person shall be deprived of his life and personal liberty except according to procedure established by law. So if I ask you this question, that Sudarshan, can government legally take your life? Your answer would be yes or no. Everyone should answer this question. My statement is, can Indian government take your life legally? Yes or no? Come on, fast. You should respond fast. Answer is yes. You know why? Because it can be taken by procedure established by law. It means government cannot take your life in arbitrary manner, but legally government can take. Okay? Legally, how can take? For example, Abhishek Kumar has committed a heinous crime. Okay? We are not going to name that heinous crime, considering respect for Abhishek Kumar. But in this particular case, the court can actually pronounce a judgment of death penalty. So if a judgment of death penalty is being pronounced, what does it mean? It means now government is taking your life legally. Now you cannot say it is against my Article 21 fundamental right to life and personal liberty. At that point of time, court will say, beta, please read procedure established by law also. Okay? So it is available to both. Both means it is available to citizens as well as aliens, means foreigners. Now, two cases are important whenever you talk about Article 21. These are first A.K. Gopalan case, then Menaka Gandhi case. We also have other cases like Mohini Jain case, Unni Krishnan case, but two cases are most important. A.K. Gopalan case. A.K. Gopalan, who was a communist leader residing in Madras state. So as we got independence, the government of Madras at that point of time, issued a notice to the local police that you should put A.K. Gopalan in punitive detention, in preventive detention. So A.K. Gopalan was like, "Maine kiya kya hai?" So police said, that is why we are putting you in preventive detention. So preventive detention means you are being detained not because you have committed some crime. You are being detained because there is a possibility that you may commit some crime. So for law and order security, you are taken into custody or you may be turned into house arrest. Okay. Now, A.K. Gopalan said, give me the reason why I am put on preventive detention. What kind of threat I am to society. So police said, okay, we are going to give you this reason, but you cannot give this reason to court. Now A.K. Gopalan said, Acha, you are fearful of court. So at this point of time, it is A.K. Gopalan filed a case in Supreme Court using Article 32 that my fundamental rights are being abridged. A.K. Gopalan asked Supreme Court to issue a writ of habeas corpus. We are going to discuss this writ of habeas corpus when I am going to talk about Article 32. But for simplifying things for you, please understand, A.K. Gopalan leveled put a case against government saying my detention is illegal. So now this case was discussed, A.K. Gopalan case. So in that case, advocate of A.K. Gopalan said, sir, this police, this government is not allowing us to actually discuss the grounds on which A.K. Gopalan is detained. Now they were like, how can this happen? Court can ask any detail about the case. So the government said, no sir, means the government, the department which arrested A.K. Gopalan said, no sir, we cannot allow sharing of detail of A.K. Gopalan case, the ground of A.K. Gopalan case before you. Supreme Court said, ye kya mazak hai? So police department said, sir, in preventive detention law, there is section 14. In preventive detention law, section 14 says that no detail on the ground of arrest can be furnished before any other authority. So any other authority means court is also the other authority. So Supreme Court said, bakwas hai section, nikalo isko. So at that point of time, in A.K. Gopalan case, Supreme Court used doctrine of severability. Severability word comes from the word sever, S-E-V-E-R. Sever means to cut, means cut this provision out of this preventive detention law and other sections will be allowed. Okay, means A.K. Gopalan sahab, you will remain in preventive detention because grounds are there, but this basis will be shared. Okay, so procedure established by law was used there. It means court said we have gone through the procedure. So it means this particular police department has followed the procedure mentioned in preventive detention law. They have not flouted any procedure. That is why it is justified. Okay, that is why it is justified, but this section is out. Okay, so at that point of time, A.K. Gopalan said, sir, this particular section is unreasonable. This is unjust. Supreme Court said, no, we only use procedure established by law because in Article 21, Constitution mentions procedure established by law and Supreme Court is interpreter of Constitution. So at that point of time, you can see that the power of Supreme Court was quite limited to procedure established by. They were just checking the procedure, if it is followed or not. Okay. So protection only against arbitrary executive action. UPSC is going to ask question from here. Please remember the detail. It means arbitrary executive action should not be there. It means purpose of executive is to execute the law. So department was executing the law in correct manner. Supreme Court said we cannot actually put a question on arbitrariness of legislative action because legislative action means to make law. So Supreme Court said no, we are not going to question a law made by Parliament. Okay, we are there to check whether that law is implemented by executive in correct manner or not. Right? So this is the meaning of this. Personal liberty, liberty relating to a person or body of individual. So liberty as a word in Article 21 is mentioned here. Then there was Menaka Gandhi case, wonderful case. The case was Menaka Gandhi was given a notice by Regional Passport Office in Delhi under section 10 subclause 3 of Passport Act. And she was said, madam, you just submit your passport and we are going to impound your passport. Menka Gandhi said, why you are impounding my passport? Regional passport officer said, ma'am, in public interest. So Menka Gandhi said, at least give me some time to actually present my rationale that it is not good to it is not fine to actually take my passport. Regional passport office said, ma'am, we are just following the procedure because it is mentioned in section 10 subclause 3 of this passport act. So Menka Gandhi filed a petition, put a case in Supreme Court that this is against my fundamental right. Because before that, Sardar Satwan Sahni case was already, discussed, and Supreme Court said that right to move abroad is a fundamental right. And if you impound someone's passport, can that person go out of India? No, that person cannot go out of India without passport. And that is why this particular case was taken up. And this particular case actually added a new dimension in Indian polity. Right to life and personal liberty can be deprived. And now, in A.K. Gopalan case, Supreme Court said we are going to follow just the procedure established by law. But here Supreme Court said, no, now we are increasing our power. Now I am going to use due process of law as well. What is the meaning of due process of law? It means now we are going to check whether a particular section is just reasonable or not. It means now we are not going to remain silent कि ठीक है section follow हो रहा है कि नहीं. Now we are going to question whether that was reasonable or just or not. Because Supreme Court said if someone made the law, that law was made to actually have a justice there, right? No injustice based, no section which is based on injustice cannot continue. So in this case, Supreme Court expanded its power, incorporated due process of law. Please remember, concept of due process of law was added through taking inspiration from American system, means US system. But when it comes to process established by law, it was taken through British system. Okay? Against arbitrary action of both executive and legislative. Please remember this difference. In A.K. Gopalan case, against arbitrary action of executive, now against legislative also. If UPSC make a statement, what is the status now? Now Supreme Court can question arbitrary action of executive as well as legislative. With existence and survival, right to live a dignified life is implicit. Means Supreme Court said in Menka Gandhi case that in Article 21, right to life and personal liberty is used. Life is not mere inhaling and exhaling. Right also include a dignified life. It means whatever necessary for a dignified life should be considered as a fundamental right. And from there, my friends, we saw Mohini Jain case where Supreme Court said, oh, education is important for a dignified life. In Unni Krishnan case, Supreme Court again said education is important for a dignified life. And that is why, my friends, later we had a separate article added in our fundamental right, Article 21A, as right to education as a fundamental right. Now attempt this question. Which rights are known as golden triangle? Because this golden triangle was a contribution of Menka Gandhi case. Because in Menka Gandhi case, Supreme Court said Article 14, 19 and 21 should be read together to understand the essence of these provisions. They should not be read exclusively. Now some of you might say, sir, samajh nahi aa raha, what is this golden triangle and why we need to read these three rights together? All of you are aware of Article 14, equality before law, equal protection of law. All of you are aware of Article 19, right to freedom. We just explained. Article 21, right to life and personal liberty. All of these three articles, when they are read together, they establish a principle of natural justice. And when they are read together, they also represent constitutionalism. It means the government should be restricted from taking arbitrary action, right? So this is golden triangle. This is the contribution. Now analyze the difference between procedure established by law and due process of law. I have just mentioned you through the case A.K. Gopalan and Menka Gandhi case, but UPSC can make specific keyword based statement. So please remember, there's less scope in process established by law. We saw in A.K. Gopalan case, there's large scope. Why? Because executive plus legislative. Here only on executive Supreme Court can question. correct process means Supreme Court was just checking whether correct process was followed. Here check the law itself, whether that law is correct or not. Originated from British Constitution, originated from United States Constitution. So now you can simply understand this. It is procedure established by law. When you add masala of principle of natural justice in procedure established by law, what you get? You get due process of law. Please remember it. This reflects your conceptual understanding, right? Now, in Article 21, as I told you, it has elaborated. So we have number of rights declared as fundamental right now. Right to medical care, right to food, right to livelihood, right to privacy, important Puttu Swami case, right to healthy environment, right to education, right to shelter, all of them are now emerging from Article 21. So now Article 21 carry a variety of rights. Right to privacy, Puttu Swami case. Please remember, right to privacy is also not absolute. Means there may be some reasonable restriction scopes, right? Right against sexual harassment of women at workplace. In this judgment, Supreme Court said, if women are being exploited in workplace sexually, then this can be considered as right against Article 21 because it is against their life and personal liberty, right? And there Supreme Court issued Vishaka guidelines on whose basis we had a protection of Women from Sexual Harassment Act 2013. But my friends, reality is I have been part of Delhi government. I was working with Minister for Social Welfare as a consultant for some time. So at that point of time, I observed that most of the organizations, private, I'm focusing on private one, they are not following this protection of the details mentioned in Protection of Women from Sexual Harassment Act 2013 because there's a mention of LCC, Local Complaint Committee. If we talk about inorganized sector, Internal Complaints Committee, if we talk about organized sector. But these laws need to be adhered to give women a better place to work. Now, when you say right to life, does it also include right to die? Answer is yes. Right to die with dignity. Although, right to death is not part. It means you cannot say, oh, I have right to life means I can also commit suicide. No. It is not correct. But right to death was discussed with respect to case of euthanasia. Here you can see this image. Aruna Shanbag. She was a nurse in KEM hospital in 1970s and she was sodomized by a lab boy. And she was strangulated with chain in such a way that she went into coma. That person went into jail for 6 years and now he later got released. But the point is, at that point of time, that person was not charged with rape because IPC section 376 rape section was not considering anal sex, means sodomy, as you can say in the definition of rape. Although after this Justice J.S. Verma committee report, now sexual harassment sections have elaborated a lot, but people actually took this challenge in their hand when this Nirbhaya case happened. I hope you remember the details at that point of time. But after this Aruna Shanbag case, Supreme Court accepted that because she was in utter pain and our constitution, our law was not allowing her to die peacefully, that is when Supreme Court accepted passive euthanasia. Passive euthanasia means if person is terminally ill, that person cannot be saved. In that case, life support system can be turned off. If life support system is turned off, then that person can die. But you cannot have active euthanasia. Active euthanasia means you have to give some chemical or something from outside so that that person die. This is illegal in India. And passive euthanasia is applicable, but that too in selective cases. I hope it is clear to you. Due to paucity of time, I have to rest my voice here. I am getting signals from outside. So, sorry for that. In next session, I'm going to continue from here. Till then, keep learning, keep growing. Shashank.